Well, the first thing is to tell them to be absolutely sure that that's what they want to do. My own career ran along fairly traditional lines of an English barrister. I went to the bar uh, and I had no idea at that stage that I wanted to be anything other than a barrister. I had no idea that I might want to become a judge, and the idea of becoming an arbitrator would simply not have been on the horizon. So when you're a young person, when you haven't had much experience and you don't really know very clearly what you want to do with your life, I think you have to have a slightly open mind about things. But there are some people, I'm sure, who know from a very early age that they want to be arbitrators. There'll be others who will have a career profile a bit like mine, and at some point along the way, they may decide that they want to switch from being an advocate, for example, to becoming an arbitrator. So, first advice would be that they be absolutely sure that they do want to become an arbitrator. I think that's the starting point. Sports cases come in all sorts of shapes and sizes. Many of them are not arbitrations at all. They are regulatory, disciplinary cases, um, and they call for very different treatment from arbitrations. But there are some arbitrations in the world of sport. I have done quite a number of them since I retired as Master of the Rolls about 6 or 7 years ago, but I fell into that by chance. Life throws up opportunities, and I've always taken the view that when an opportunity presents itself, unless it's something that is obviously something you don't want to do, then you should have a go. The worst that can happen is that you decide you don't like it. Anyway, sport. I'm interested in sport. I always have since I was a boy, and I'm interested in the subject matter of sport. So, to answer your question, I don't think there's anything very special about sports arbitrations. I'm leaving regulatory, disciplinary matters on one side and just answering the question by reference to arbitrations. And I don't think there's anything very specially different about sports arbitrations from many other kinds of arbitrations. They are disputes, they are subject to various legal requirements, and the subject matter of sports arbitrations is obviously sport, which is different from, say, commercial arbitrations, or indeed family arbitrations, although I've never done any of them myself. The basic principles are the same. You have to understand what the issues are. You have to conduct a fair hearing. You've got to produce your decisions reasonably quickly, and all those sort of things which go without saying, but they are equally applicable in the sports arena as they are in any other. No, not at all. I mean, some sports arbitrations are complicated, but on the whole, my experience has been that they have been rather simpler than many of the heavy commercial arbitrations. I've been doing a number of heavy international commercial arbitrations in the last 2 or 3 years, and some of them have been extremely complicated, hearings running for 3 weeks, voluminous documentation, a lot of law, whereas most sports cases, not all, but most sports cases are much shorter, do not involve masses of documentation, don't involve a lot of law. They involve other challenges, obviously, but no, I think the answer is on the whole, and I'm generalizing, of course, but on the whole, I would say that sports arbitrations are much simpler and less complicated than most commercial arbitrations. I should say most commercial arbitrations these days, in my experience, are international commercial arbitrations. Domestic commercial arbitrations seem to be relatively few and far between now. And of course, the international dimension brings its own complexity. That's an impossible question to answer. I can tell you what puts me off, which is a very, very heavy, complicated commercial arbitration, which has got very little, if any, law in it, which has just got a mass of documents, all on facts. When I was younger, that kind of case appealed to me. As a young person, you are excited to get anything, frankly. And when you're younger and you perhaps got a bit more energy, you're quite happy to roll up your sleeves and get stuck into a very complicated, fact-heavy case. These days, that really doesn't appeal to me a great deal. So, on the whole, these days I prefer shorter cases, cases which have interesting points of law in them, cases which have difficult disputes of fact, technical disputes of fact, anything like that I find interesting, but disputes on the facts, particularly in, say, construction cases, of which there are many, where you have to trawl your way through thousands of documents to work out what happened. Those cases have lost their charm as far as I'm concerned, but that's because it's a very subjective thing. I mean, what excites me and interests me is not necessarily the same as what interests the next person. But I think on the whole, people who've been around a long time, as I have, are less interested in those sort of heavy, complicated, fact-heavy cases than the sort of cases I've described. So I'm not sure if I've answered your question directly. I've answered it in a sense negatively, but I hope it's clear what I'm saying. I find that a difficult question to answer. I can identify two major events, which I'm not sure if they fall into that description, which have impacted on some of my cases, and I know have impacted on many other cases. The first one is COVID, which played absolute havoc with so many contracts and the performance of so many contracts, giving rise to questions of whether in a contract which has a force majeure provision, that provision was engaged, and also whether, as a matter of common law, whether the contract was frustrated by COVID. And I had a very interesting sports case, actually, about 18 months ago, involving the Hungarian Lawn Tennis Federation. And the question was whether the Hungarians were required to stage the Billie Jean King Cup in Hungary, or whether, because of COVID, they were not. And we had to look at a very complicated contract, so it was really a commercial case, although you could say it was also a sports case. And so that was an example of how COVID has been affecting arbitrations. And the other, as it were, extraneous or external event that I would mention, which I'm not sure if falls technically within your category, has been the sanctions on Russia as a result of the invasion of Ukraine. And that has caused a lot of problems. I've had two arbitrations involving Russian parties, which had to be stayed, had to be suspended, because one of the parties was Russian. And the question of the impact of the regulations on Russian parties was relevant to that. So, and I know that that has been an issue and a problem in other cases as well. As I say, I'm not sure. I don't think that either of my two events, my two examples, falls into your category, and I'm not sure that I can immediately think of an event which does fall directly into your category.